6301. Okay, so this question says, which, if any, of the following are true concerning a preliminary injunction? 1, may be granted ex parte. No, that's wrong. Has to be on notice. Preliminary injunction is always on notice. 2, it must appear that immediate and irreparable injury, loss, or damage will result unless defendant is restrained before a hearing can be had. And that would be true if it was a TRO. Now, in the question, it says or, but I'm reading that as an and because I have so much trouble remembering that it is an and. 3, unless the court orders otherwise, a motion for a preliminary injunction along with the papers upon which it was based and a notice of hearing for the preliminary injunction shall be personally served in the same manner as a summons. That's also wrong because that is the language they're using for a TRO. 4, prior to the granting of a preliminary injunction, court may require plaintiff to give an undertaking in amount fixed by court. That's also false because it says that plaintiff shall give an undertaking. All right, 2 is in 6314. It says, which, if any, of the following are false concerning a motion to vacate or modify a preliminary injunction? So the first one says a motion for this relief may be made with or without notice. Now, that is false because it can only be made on notice. The same way you can only get a preliminary injunction on notice, you can only move to vacate or modify it on notice. 2, in general, the court may require the moving party, defendant, to post an undertaking. That's true. 3, an order granted without notice, vacating or modifying preliminary injunction, shall be effective when the papers on which it is based is filed with the clerk and served upon the plaintiff who received the preliminary injunction. Again, that's wrong because it's only on notice. And that language is talking about specifically a TRO. 4, a defendant enjoined by a preliminary injunction may move at any time to vacate or modify it. So that's true. And this question is very tricky because it's asking you which is false. So as you go through them, the way that I do it is I'll put on the paper there little f next to the ones that are false. And then when I go to look at the choices, I already know I'm looking for which is false. Question 3. A motion for an order of attachment or to confirm an order of attachment. The plaintiff must show, and this, thank God, they're all true. The plaintiff must show 1, that a cause of action exists. 2, that one or more grounds for attachment in 6201 exist. 3, that the amount demanded from the defendant exceeds all counterclaims known to the plaintiff. And 4, that it is probable plaintiff will succeed on the merits. 7003. If a judge improperly refuses to issue a writ of habeas corpus, he forfeits to the person detained $1,000. Question 5. CPLR 7006. If a person to whom the writ of habeas corpus is served refuses or neglects to obey it without showing sufficient cause, upon proof of service, the court shall forthwith issue a warrant of attachment against him and may order he be committed to the county jail until he complies with the order. And it also says that the warrant of attachment directed to the sheriff in any county in which he is found will require him to be brought before the court and may order he be committed to the county jail until he complies with the order. Okay, I'm skipping question 6 because the arbitration stuff is at the end. So this is question 7. CPLR 7011. With regard to an appeal on an Article 70 proceeding, an appeal may be taken from a judgment upon the return of such a writ or an order to show cause, or a judgment refusing to grant a writ of habeas corpus or an order to show cause. Question 7A. CPLR 7803. Which of the following questions may be raised in an Article 78 proceeding? And the answer is all of the above. So 1, whether a body or officer failed to perform a duty enjoined upon him or it by law. 2, whether a determination was made in violation of lawful procedure. 3, whether a determination was arbitrary or capricious. 4, whether a body or officer is proceeding without or in excess of jurisdiction. 5, whether a determination made as a result of a hearing held at which evidence was taken was supported by substantial evidence. 8, 7804. Unless the court grants an order to show cause, an Article 78 must be commenced by filing a notice of petition and petition, which the petition must be verified, and serving them on any adverse party at least 20 days before the time the petition is noticed to be heard. Answering affidavits, the answer shall also be verified and has to be served at least 5 days before such time, and the reply at least 1 day before such time. Okay, next is question 9. This is 7804, and it's also actually in the venue question. So it's also in 506. Generally, Article 78 proceedings may be brought in the Supreme Court in any county within the judicial district. 1, where the respondent made determination or refused to do his duty. Or 2, where proceedings were brought, blah, 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 matter to be originated, something like that. Or 3, material events took place. Or 4, where respondent's principal office is located. And then there's, in 506, there's a whole bunch of if it's against the Justice of the Supreme Court, it's got to be brought in the Appellate Division, blah, blah, blah. And if it's against the Board of Ed, it's got to be in Albany County. If it's against the New York City tax thing, it has to be in the Appellate Division, First Department. Okay, next, number 10, this is CPLR 7804. An Article 78 proceeding is commenced in Supreme Court. After review of the papers, the justice finds that he can dispose of all the issues raised without a hearing, except for the issue of whether or not the determination after a hearing was supported by substantial evidence. At this point, the justice should make an order transferring the proceeding to the Appellate Division. Question 11. 7009. When a writ of habeas corpus is ordered to produce a person in detention by virtue of a mandate, the court shall not adjudicate the issues in the proceeding until written notice of the time and place of the hearing has been served either personally 8 days prior to the hearing or in any other manner or time as the court may order. Okay. Question 12, 7804 and 506. An Article 78 proceeding against the Justice of the Supreme Court must be brought in the Appellate Division in the Judicial District where the action, blah, 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 originated is triable, unless it's not in session, then the adjoining JD. All right, question 13, I already did that in the other question. That's just the time rules. Question 14, 7805. In an Article 78, proceeding seeks a stay of order of judgment granted by the Appellate Division. Such a stay may only be granted by either the Court of Appeals or the Appellate Division. Question 15, CPLR 7005. A writ of habeas corpus may be served on any day. 16. 7002. This is a tricky one. Which, if any, may never entertain a writ for habeas corpus? So basically, the only one out of this list was the Court of Claims judge. There is things like conditions before the county judge is allowed to hear it. And I believe that in the petition, the petitioner actually has to say when he's putting it in front of a county judge, what gives the county judge the authority to act. All right, next. 7007. This is question 17. A court authorized to issue a writ of habeas corpus shall also issue a warrant of attachment for the person detained upon satisfactory proof that a person is wrongfully detained and will either be removed from the state or suffer irreparable injury before he can be relieved by habeas corpus. So basically with this, even though the only answer I was actually looking for was warrant of attachment, there's like a lot of information in it because it's telling you when this can happen. They have to show, number one, no matter what, they got to show he's wrongfully detained. And then they either have to show that he's going to be removed from the state, or two, that he's going to suffer irreparable injury before he can be relieved by habeas corpus. Okay. 18, this is 8020, sub D. For filing a stipulation of discontinuance or a stipulation of settlement in Supreme or County Court, the county clerk shall be entitled to a fee of $35. Okay, 19. 8020 sub A. The county clerk is entitled to a fee for $125 for the filing of the note of issue, which is to place a case on the calendar for trial or inquest. A fee of $95 for the RJI in counties where the rules of the fucking chief administrator has required one, and a fee of $45 for every motion or cross motion filed in an action, except a motion to proceed as a poor person, for which the fee shall be $0. Okay. 7005. Which, if any, of the following are true? And it's all of them. A writ of habeas corpus may be served on any day. True. Service of the writ shall be made by delivering the writ. True. If the person who is to be served cannot be found, the writ may be served by leaving it and a copy of the petition with any person who has custody of the person detained at the time. And if the person to whom the writ is directed conceals himself or refuses admittance, the writ may be served by affixing it in a conspicuous place or on the outside of either his dwelling. If the person to whom the writ is directed conceals himself or refuses admittance, the writ may be served by affixing it in a conspicuous place on the outside of either his dwelling or of the place where the person is detained, and mailing a copy of the writ to him at such dwelling or place. So that was all of the above. 7806. True. Any restitution or damages granted to a petitioner in an Article 78 must be incidental to the primary relief sought by petitioner. 5224 sub B. This is true. A debtor served with a subpoena under CPLR 5224 and any other person served with an information subpoena shall not be entitled to any fee. 7801. Which, if any, of the following reliefs previously obtained by writs of certiorari, mandamus, and prohibition are now obtained by commencing in Article 78? It's those three. And a writ of certiorari is actually the writ to review. That's what it means. So that's why it's not called writ to review.